Welcome everyone. We've got Andrew Dahdal. He's a lecturer, and he's going to be speaking at the Mises seminar in November. I wanted to get him on the show to sort of talk about, what he's speaking about and his background and all the kinds of interesting things that we want to know about the speakers before we go to the seminar. So welcome to the show, Alan. Thanks for coming.
Thank you very much. Pleasure to be
here. So tell us a bit about yourself.
I'm a lecturer at Macquarie University. My academic background is in law. I finished my law degree several years ago at Macquarie University, and I'm presently doing a PhD at the University of New South Wales. My areas of interest are constitutional law mainly, but I'm teaching in commercial law, so anywhere where commercial law and constitutional law intersect is a place I'm really interested in.
And so, how did you hear about the Mises seminar?
Actually, there's a libertarian group that just started at Macquarie University.
Yeah.
And I was contacted by some of the members because I think I'd left a message on the Liberty Australia website.
Yeah.
And they informed me that they were organising the Mises seminar, and to my surprise, it was not only in Sydney but at my institution, Macquarie University.
Yeah.
I was very, very keen and excited for that.
So, what about the ideas of liberty? Have you had much familiar background with that? Or
yeah.
Libertarianism and Austrian economics and the topics of the seminar?
Well, yeah. It's essentially, you come to this position after you explore all other possibilities and political perspectives, and inevitably you'll find them all wanting. So this is essentially a default position when you meet someone who shares these ideas with you about non-authoritarian rule and individual freedom. You hope at least that they've thoroughly explored all other alternatives and honestly come to the conclusion, as I think I have, although it's constantly a conceptual struggle if you're really honest with yourself, that the idea that no one can force you to do what you don't want to do, especially the government, is just an axiom of human existence.
Yeah, it's a very simple idea, really. I mean, just don't use the government to commit force and fraud, and just don't tax too much, don't regulate too much. Let people, as long as they're not hurting anyone else, just let them do what they want, pretty much.
I mean, if you want a system to allow human nature to express itself, I think you're going to find it difficult because you can't quantify what human nature actually is. You just need to provide a context within which people can express themselves entrepreneurially, intellectually, academically, emotionally, and if you're going to impose a framework, political or otherwise, or economic, upon people, then you're just going to be creating cardboard cutouts consistently. You're not going to really be in a society which is populated by interesting and authentic individuals.
Do you have any particular thinkers or that you would that have influenced you, or particular writers?
Well, economically, when you get onto these ideas of liberty and Austrian economics, you can't go past the big guns of Mises and Rothbard. So in the economic context of applying these principles to the commercial world and economically and drawing them out to their natural conclusions, I would say Rothbard's writing has been very telling and informative for me.
What about in your particular area of law? Are there any particular writers, maybe libertarian leaning or something like that?
Well, in law, you can't go past Bastiat, Frederick Bastiat. There's a small essay written some 250 odd years ago. I think it's just called The Law. And anyone who's studying law, I mean, you need to keep a copy of this in your back pocket at all times. it just clearly spells out the function of law is to protect life and liberty, not to be wielded as a tool of special interest groups or other types of people who want to hijack the power of the state. The law shouldn't be a tool or a mechanism or an instrument for that purpose, but should be a bulwark for freedom and against authoritarian oppression.
And so, did you know about these ideas before you chose your PhD topic, or did you recently come to them?
No, look, I would say I'd probably come to them as a result of my PhD topic, because my topic is on the banking power, the power of the federal government to make laws with respect to banking under the Australian Constitution. And when you're trying to discern the relationship between the state and the institution of banking, you can't go past Hayek. Hayek's works, he's a Nobel economics winner, Nobel Prize winner in economics, and his work on the denationalization of money and just teasing out the intricacies of the relationship between the state and the ability of the state to produce money and control the banking system, provided me with the groundwork, the conceptual framework to understand the tensions at play.
This is probably a good time to ask, what are you actually going to be speaking about at the seminar? I mean, it's going to be based on your PhD topic, I take it?
Well, yeah, a part of my PhD topic, there's part of the banking power. The banking power is specifically Section 51, subsection 13 of the Australian Constitution. And this section grants the federal government specific powers called exclusive powers, and everything that's not granted to the federal government is residual power left over for the states. Now, the banking power specifically gives the power to the federal government to make laws with respect to banking, other than state banking, the incorporation of banks, and the issuing of paper money.
Yeah.
I'm just going to limit my talk to that last element, the issuing of paper money.
Yep. And you're arguing that the Commonwealth government does not have the power to issue paper money.
Well, look, it's an interesting argument. I'll confess from the outset that, and I may ruin the ending for some of the attendees at the seminar, but I'm going to fail in the argument that the federal government does not have the power to issue paper money. And the reason is the way in which the Constitution is interpreted by the High Court.
Yeah.
The approach that the High Court has traditionally taken to interpreting the Constitution is to provide the words in the Constitution with as much generality and liberality as possible. And so the words issuing paper money will inevitably be interpreted, should this controversy or a controversy involving this aspect arise in front of the High Court. The court, I believe, will inevitably, because of its interpretive approach, interpret it to mean that the government has the power to issue paper money. Now, the thrust of my research in my PhD is to say that the appropriate way to interpret the Constitution is to bear in mind the history surrounding its formation and the historical context in which it was drafted. Now, that's not necessarily to say that the original intention of the framers is what should dictate the meaning of the Constitution. But what I'm saying is, if you really understand the economic context of the late 19th century in Australia, you would know that the phrase issue paper money specifically referred to the issuing of paper money by private banks, which was quite common from about 1850 till 1910.
Yeah, I remember I've read some stuff on this by Kevin Dowd, and I think he's a libertarian author, and he's written about how we had free banking for a lot of Australian history. Private banks would issue their own notes, and
not only was there free banking, the Australian experience is a poster child for free banking.
Yeah. And I did a law degree before I did my politics honors, and I'm very aware that the High Court, takes a very broad approach, since the engineers case. And so you're saying basically that you have this argument, but it's never going to get accepted by the High Court. But I think it's still worth making the argument.
It is worth making the argument, and the reason is since there was a major turning point in the interpretive approach of the High Court in the late 1980s, a case called Cole versus Whitfield. And in the case of Cole and Whitfield, for the first time, the court actually based its judgment on the records of the convention debates that were, copiously kept in the 1890s. Every word that was stated in a debate where the Constitution was drafted was kept. And so, from the case of Cole and Whitfield up until the most recent case only a few weeks ago, especially under the Chief Justice French, the High Court now is more and more relying on history. History has become an entry point into their analysis, a context-setting approach to how they interpret the legal materials. So I'm hoping that through my work and my research, that if I can provide this historical context for the banking power, then I think it's a bonus that the historical context also supports the kind of libertarian outlook that I believe to be correct. But I just want to lay it out there. Should a controversy arise in this particular context, the High Court will have something to draw on.
So, what specific things about the historical context support your argument?
Well, before we even get to historical context, you look at some other sections of the Australian Constitution. There's, for example, Section 115 specifically states that the states are only allowed to make gold and silver coin legal tender for the payment of debts. Like you can't get plainer than that. That the Constitution was intended that, the federal government wasn't going to issue money. That was going to be a responsibility of the states, and they just wanted to make sure that the states didn't issue fiat currency. We had hard currency. We had gold and silver coin. It's clear that the drafters of the Constitution looked back at the American experience of the 18th century and the Articles of Confederation and the disaster they had with fiat currency in the Revolutionary period. And they wanted to make sure this didn't happen in Australia. So they inserted Section 115 that said states can only make gold and silver coin legal tender. So you've got the phrase legal tender and you've got the phrase paper money. Paper money was not meant to be legal tender. Paper money was just the medium of exchange signifying the legal tender that was kept in banks. We've now had a conflation of the terms. Paper money is now legal tender, and the original economic framework under which the Constitution was drafted no longer exists.
I just want to play it quickly. There's an American author called Tom Woods. And
we're all very familiar with Tom Woods.
Yeah, and he's made a similar argument in the American context. And I just want to quickly play a clip by him where he talks about how even though it says states, this provision actually sort of operates onto the federal government as well.
What they're saying, it seems to me, against Ron Paul, is that it's only in Article 1, Section 10 that deals with restrictions on the states that we read that only gold and silver can be made legal tender by the states. But the argument is, well, then the federal government can apparently make anything it wants to legal tender. Well, that fails on a couple grounds. One is that there's an obvious contradiction. If the federal government declares copper coins to be legal tender, and the states, as is their prerogative, declares gold and or silver coins to be legal tender, well, then there's a dilemma, a constitutional conflict, a legal conflict, confusion. So obviously the federal government would be limited in what it declares to be legal tender to what the states are allowed to declare to be legal tender. But secondly, where does the federal government have a delegation of authority that authorizes it to make any legal tender at all? And that's a good question. There really is no answer to that. It's not been taken up in a satisfactory way.
Okay, so that's Tom Wood's take. And a lot of people might look at that provision, Section 115, and say, that only restricts the states. The federal government can do whatever it wants. How would you respond to that?
Yeah, look, the Australian Constitution and the American Constitution, whilst they're both federal structures and whilst they both give federal government exclusive powers, and there's a lot of similarities, there are some differences. And this is where it's a bit of an uphill battle for the Australian context if you're trying to confirm the argument that Tom Woods just expressed there. And it is that Section 51, subsection 12 of the Australian Constitution actually specifically gives the federal government the power to make laws with respect to currency, coinage and legal tender. The American Constitution doesn't do that. The Australian Constitution does. So whilst it would seem that the states are limited to gold and silver coin, the federal government in the Australian context looks like it can make laws with respect to legal tender on a broader basis than just gold and silver coin, which is, essentially how they've gone about conflating hard currency and paper money, legal tender and paper money.
But at the same time, it couldn't force the states to use anything else apart from gold and silver?
No, it couldn't. The states are not allowed to make anything but gold and silver coin legal tender. I mean, the Skyring case, which I mentioned to you earlier in a previous conversation, there was a litigant who went before the Australian High Court, and he's argued on several occasions, to the extent now that he's been listed as a vexatious litigant, meaning he can't bring any more cases before the federal courts without leave of the court. And he's argued that the states requiring that candidates in a state election pay their candidacy fees in paper money is unconstitutional, which on the face of it seems quite logical. The Constitution says specifically the states can't mandate that anything but gold and silver coin is legal tender. If you want to pay your fees to be a candidate in an election, you have to pay with you have to pay with legal tender. The states are saying you have to pay with paper money. That's not gold and silver coin. You've got a contradiction there. On this basis, he extended the argument out quite a bit, saying, well, politicians who were elected to Queensland Parliament were then not properly elected because they did not correctly comply with candidacy requirements. Therefore, the laws that they passed were not valid laws because they weren't actually members of Parliament. And therefore, it all comes down to him trying to fight a bankruptcy proceeding against himself. And he was saying the bankruptcy laws to which he was subject were therefore unconstitutional. Unfortunately, the court really didn't take the argument seriously. And we've never had the court actually address this particular issue head on.
Yeah, I did read a federal court case about this, and the court sort of seemed to dismiss it just by saying that, it only applies to the states or something, and didn't really go into the objections to that argument.
No, it didn't. I mean, one of the appeals that Mr. Skyring brought further to his initial litigation was that the court didn't exercise judicial power because it didn't give reasons for its decision. And again, that argument was rejected as well, which, judicial power is a difficult concept to define under the Constitution, but at a bare minimum, it must include giving clear and logical reasons for the conclusion. Dismissing something out of hand without giving reasons is just, undemocratic.
Well, yeah, this sort of brings us to the final part of the interview, which is the political implications. And I think that a lot of the court's thinking in this regard might be that they don't want to rule it unconstitutional because that would change so much of the fabric of society and it would change so many things, and they might not have read Rothbard, they might not know about competing currencies, so they might be hesitant to actually give this argument any consideration because of the politics of it. I'm always this particular line of thinking. I'm always a bit uncomfortable with when in libertarian schools of thought when they say the courts are just an extension of the state, and it's the state being a judge in its own controversy in its own proceeding. So how can you have I think that really sells judges short. Judges are, reasonable individuals, highly intelligent, highly motivated, but they exist within a particular system. So, to say, a particular intellectual tradition, a particular political and legal upbringing, a particular mindset prevails. So,
to say, outright that that judges may be reluctant to take the argument seriously because they're trying to, uphold these institutions. Whilst on some levels that may be justifiable, I don't think it's a conscious effort on the part of judges. I think most judges or all judges, I like to believe, come to a proceeding in good faith and with an open mind. Not really considering the political ramifications. They would leave that up to other branches of the state, to the legislature. But in constitutional cases, the court always has to have a mind on political consequences. But I don't think it's fair to say that these political consequences are what drives the court in these decisions. I think that's too blunt of an argument. You need a little bit more of a, just generally speaking, a bit more of a sophisticated understanding of how the court comes to its decisions and why these decisions inevitably seem to always come down on the side that is antithetical to what you and I think is right in the libertarian tradition. We really need to peel back the layers and understand what's going on here. It's not just them towing the barrow, so to speak.
All right, so I think I'll just wrap it up here. I'm really honored that you came on and talked about your work, and it's going to be amazing to have you speak at the seminar.
Thank you. You're too flattering.
I think that the seminar, everyone is going to be interested in this argument because, a lot of libertarians, they want the gold standard, they want honest money, and I think to have some sort of legal arguments is really good in terms of intellectual ammunition. We also have Chris Leithner at the seminar. He's written a book about the RBA.
Yes, I'm familiar with his work.
Attacking the RBA and saying these kinds of things. So to have you combine, along with Simon Hoppa, would be just amazing. All right, so thanks a lot again for coming on, and wish you the best.
Thank you. All the best.
RBA Board Secretary Tony Froth joins me from Sydney.
We just do the paperwork on the issuing of banknotes, so we get to say what they're worth. That's pretty much it.
Right. How do you work that out? I suppose relative to the gold reserve, isn't it?
No, we've sold the bulk of our gold reserves. Look, it's all based on the value of our reserves of foreign currency.
Okay.
No one uses gold these days, Sean. My God, where have you been?
Although if no one uses gold and everyone's using everyone else's currency to value their money, then surely it's ultimately not worth anything. Tony Froth, many thanks.
That's the beauty of a free market.
But it's not a free market, is it? You're interfering with it.